Basic concepts of political law. So, under the 1987 Constitution, what is the nature and concept of a constitution? Right. So, a constitution is a system of fundamental laws for the governance and administration of a nation. It is supreme, imperious, absolute, and unalterable except by authority from which it emanates. Since the Constitution is the fundamental, paramount, and supreme law of the nation, it is named written in every statute and contract. What are the essential qualities of a written constitution? First, it must be broad, that it should provide for the entire governmental organization, cover all persons and things within the state territory, embody the past, reflect the present, and anticipate the future. Second, it must be brief, having the basic principles to be implemented with legislative details more adjustable to change and easier to amend. And third, it must be definite to avoid confusion and divisiveness among the people. An exception to this is those provisions deliberately worded in vague manner, like the Due Process Clause, as to make them more malleable to judicial interpretation in light of new circumstances. What are the essential parts of a good written constitution? First is the Constitution of Liberty, where the provisions prescribing the fundamental civil and political rights of the citizens and the limitations on the powers of the government to enjoy those rights. Second, the Constitution of Government, the provisions outlining the organization of the government, enumerating its powers, laying down certain rules relative to its administration, and defining the electorate. And third, the Constitution of Sovereignty, the provisions on the mode or procedure in accordance with which formal changes in the fundamental law may be brought about. What is the concept of constitutional supremacy? Under this doctrine, if a law or a contract violates any norm of the Constitution, that law or contract, whether promulgated by the legislative or by the executive branch or entered into by private persons for private purposes, is considered null and void and without any force and effect. Thus, since the Constitution is fundamental, paramount, and supreme law of the nation, it is deemed written in every statute and contract. Therefore, a contract which violates the Constitution is void, and it will not permit to be done indirectly, which, because of public policy, cannot be done directly. Self-executing character of the Constitution. The general rule and presumption is that the provisions of the Constitution are self-executing in character. Self-executing clauses refers to those in the Constitution that are effective without the need of an enabling statute or law. A provision which is complete in itself and becomes operative without the aid of supplementary or enabling legislation, or that which supplies sufficient rule by means of which the right it grants may be enjoyed or protected, is self-executing. How about non-executing character? Non-executing clauses refers to those provisions in the Constitution that are ineffective without an enabling statute. The concept of amendments and revisions. Amendment is a concept that broadly refers to a change that adds, reduces, or deletes without altering the basic principles involved. An addition or change within the lines of the original instrument as will effect an improvement or better carry out the purpose for which it was framed. Revision, on the other hand, broadly implies a change that alters a basic principle in the Constitution, like altering the principle of separation of powers or the systems of checks and balances. There is also revision if the change alters the substantial entirety of the Constitution, as when the change affects substantial provisions of the Constitution. An amendment to the Constitution may be proposed by initiative, a constitutional convention or CONCON, or Congress acting as a constituent assembly. On the other hand, a revision may only be proposed by a constitutional convention or Congress or Constituent Assembly, and it cannot be proposed via initiative. The prevailing view is that a proposed change that meets either test must be considered a revision of the Constitution instead of a mere amendment. What are the tests? Quantitative tests. Whether the proposed change is so extensive in its provisions as to change directly the substantial entirety of the Constitution by the deletion or alteration of numerous existing provisions. So here, the court examines only the number of provisions affected and does not consider the degree of change. So if marami, that's revision. If konti, that's only amendment. But we also have the qualitative test, whether the change will accomplish such far-reaching changes in the nature of our basic governmental plan as to amount to revision. So what is the procedure to amend or revise the Constitution? First, there must be a proposal. So this refers to the adoption of the suggested change in the Constitution. If it is by a Constituent Assembly, a vote of three-fourths of all its members is required. If it is via Constitutional Convention or CONCON, it is called into existence by two-thirds of all the members of the Congress or the electorate in a referendum called for by a majority of all the members of the Congress. So if the two-thirds vote is not reached from all the members of the Congress, there will be an electorate through a referendum if only a majority was reached. So under proposal, no, the people through a people's initiative where a petition of at least 12% of the total number of registered voters where every legislative district must be represented by at least 3% of the registered voters therein. However, there is a limitation on initiative. There can be no amendment in this manner. Again, limitations on initiative. So, it cannot be done within 5 years following the ratification of the 1987 Constitution, nor more than often than once every 5 years thereafter. And it must have an enabling law. Under the case of Defensor Santiago versus Comelec, the constitutional provision on amendments via people's initiative are not self-executory. So there must be a law that will govern the procedure for a proposal in the amendment of the Constitution through people's initiative. The second part is the submission. And here we will talk about the doctrine of proper submission. So the proposal must be submitted to the people, provided there is sufficient prior dissemination of the proposed change to the Constitution. A plebiscite may be held on the same day as a regular election. But there should be no piecemeal submission. The entire Constitution must be submitted for ratification at one plebiscite only. The people must have a proper frame of reference. So no piecemeal submission is allowed. Example, submission of each amendment ahead of other proposed amendments. So it must be proposed to the people as a whole. The third part is ratification. So the proposed amendments shall be submitted to the people and shall be deemed ratified by the majority of the vote cast in a plebiscite held not earlier than 60 days, no later than 90 days after the approval of the proposal by the Congress or the CONCON, or if proposal is by initiative after the certification by COMELEC of sufficiency of petition of the people. Fourth, there will be a judicial review of the amendments. The validity of the process of amendment is not political question because the court must review if the constitutional processes were followed. Now, let's move on to the Declaration of Principles and State Policies under the 1987 Constitution. Democracy and Republicanism. So the Philippines is a democratic and republican state, and sovereignty resides in the people and all government authority emanates from them. Democratic form of government. It is a government in which the supreme authority lies with the people who exercises their power either directly or through elected representatives. A republican government, on the other hand, is where a state where is in a state where The government authority emanates from the people and is exercised by representatives chosen by the people. So next is the renunciation of war. So the Philippines renounces war as an instrument of national policy, adopts the generally accepted principles of international law as part of the law of the land, and adheres to the policy of peace, equality, justice, freedom, cooperation, and amity with all nations. That's Section 2, Article 2 of the 1987 Constitution. When, by mere constitutional declaration, international law is deemed to have the force of domestic law, generally accepted principles of international law, by virtue of the incorporation clause of the Constitution, form part of the laws of the land, even if they do not derive from treaty obligations. However, what is renounced is only the declaration of war. For Congress is empowered in Section 23, Article 7 of the Constitution to declare the existence of a state of war. Nonetheless, the outlawing of war itself is a UN declaration and thus is a generally accepted principle of international law which is incorporated in the Constitution. The supremacy of civilian authority over military. By installation of the President, the highest civilian authority, as the Commander-in-Chief of all the armed forces of the Philippines. And also through the requirement that members of the AFP swear to uphold and defend the Constitution, which is fundamental law of the civil government. State policies, independent foreign policy. So the state shall pursue an independent foreign policy. In its relations with other states, the paramount consideration shall be national sovereignty, territorial integrity, national interest, and the right to self-determination. Social justice. The state shall promote social justice in all phases of national development. Social justice, according to the case of Kalalang versus Williams, is neither communism, nor despotism, nor atomism, nor anarchy, but the humanization of laws and the equalization of social and economic forces by the state, so that justice in its rational and objectively secular conception may at least be approximated. The sanctity of family and vital role of youth in nation building, the state values the dignity of every human person and guarantees full respect for human rights. Sovereignty resides in the people and all government authority emanates from them. A state wherein all government authority emanates from the people and is exercised by representatives chosen by the people. Now let's talk about state immunity. So generally, the state cannot be sued. The state may not be sued without its consent. And international law basis is par in parem non habet imperium, that an equal does not have a power over an equal. So exception when the state consents. So suits against the state. When is a suit considered a suit against the state? One, we have to memorize this mnemonics, Luna. Ayan. So even when the suit on its face is against an officer, but the liability, letter L, belongs to or fall on the government, that's a suit against the state. Next is U, unincorporated, when the suit is against an unincorporated government agency. Next, N, name, when the republic is sued in its name. And fourth, A. Adverse, if it produces adverse consequences to the public treasury in terms of disbursement as well as loss of government property, regardless of defense. So the doctrine of non-suability applies only in cases wherein the complaint is against officials of the state for acts performed in the discharge of their duties or in their official capacity. When officials abuse this authority gravely, like discriminatory behavior, this is no longer an official state act and the official may now be sued in his personal capacity. Now the consent to be sued. Okay, so how is consent given? So it may either be expressed or implied. Expressed if it is through a general law or a special law, and implied when the state enters into a business contract with the individual performing proprietary functions, or when the state commences litigation and becomes vulnerable to counterclaim, or when it would be inequitable for the state to invoke immunity, and in eminent domain cases. Yeah, so the concept of separation of powers. Separation of powers is a fundamental principle in our system of government and is founded on the belief that by establishing equilibrium among the three power holders, harmony will result, and power will not be concentrated and tyranny will be avoided. Any system that is violative of the principle of separation of powers is unconstitutional and void. Each of the three branches of the government has exclusive cognizance of and is supreme in matters falling within its constitutionally allocated sphere. Each branch cannot invade the domain of others. The powers of the government are separated to avoid concentration of powers in any one branch. Now, the political question doctrine. This is a question in which resolution has been vested by the Constitution exclusively in the people, or in which full discretionary authority has been delegated to co-equal political branch of the government, which cannot be decided by the courts. So the determination of a truly political question from a non-justiciable political question lies in the answer to the question of whether there are constitutionally imposed limits on powers or functions conferred upon the political bodies. So if there are, then the courts are duty bound to examine whether the branch or instrumentality of the government properly acted within such limits. Now, in the case of Belgica versus Ochoa, the pork barrel system violates the separation of powers because it is a form of post-enactment authority in the implementation of enforcement of the budget. So, the pork barrel system permits legislative encroachment upon the executive prerogative of implementing the law by giving individual registration what? 1. The power to determine the projects after the GAA is passed, and through congressional committees, authority in the areas of fund release and realignment, the system encroaches on the executive's power to implement the law. Furthermore, identification of a project by a legislator being mandatory requirement before his PDAF can be tapped as a source of funds, his acts becomes indispensable and the entire budget execution process. So there is also a rule on non-delegation of legislative power. This is from the principle delegata potestas non potest delegari, or in English, what has been delegated can no longer be delegated. Since the powers of the government has been delegated to them by the people, so the power came from the people who possesses original sovereignty, these powers cannot be further delegated by the different government departments to some other branch or instrumentality of the government. So generally, only Congress as a body may exercise legislative power. Of course, we have exceptions. And what are those? Petal. And so delegation by the people to the people by initiative and referendum. E. Delegation of emergency powers to the President under the Constitution. D. Delegation of tariff powers to the President under the Constitution. A. Delegation to the administrative bodies by increasing complexity due to increasing complexity of the task of government, lack of technical competence of the Congress, administrative bodies may fill up the details of statute for implementation, and legislature may pass contingent legislation, which leaves to another body the business of ascertaining the facts. And lastly, in PETA, local governments, delegation to local governments. So to remember, that's PETAL, the exceptions to the non-delegability rule. Now, what is the test for valid delegation? So, the rule is there is a valid delegation of a legislative power when it passes the following test. First, the completeness test. And second, the sufficient standard test. When we say completeness test, the law sets forth the policy to be executed, carried out, or implemented by the delegate, such that there is nothing left to the delegate to do but to enforce the law. On the other hand, sufficient standard test is the standard is sufficient if it defines the legislative policy, marks its limits, maps out its boundaries, and specify the public agency to apply it. It indicates the circumstances under which the legislative command is to be effected. Now, let's go to the fundamental powers of the state. First is police power. So, the fundamental powers of the state is not indicated in the 1987 Constitution, but it is inherent, so it need not be written. So, we have three: police power, eminent domain, and taxation. And let's talk about police power first. So, it is an inherent and plenary power of the state which enables it to prohibit all that is hurtful to the comfort, safety, and welfare of the society. So the state, in order to promote the general welfare, may interfere with the personal liberty, property, and business occupations of its uh, citizens. Persons may be subjected to all kinds of restraints and burdens in order to secure the general comfort, health, prosperity of the state. And to this fundamental aim of our government, the rights of the individual are subordinated. Tests for a valid exercise of police power, the means purpose test, lawful subject, and lawful means. So, in lawful subject, the interests of public generally, as distinguished from those of particular class, require such interference and that the subject of the measure is within the scope of the police power. Second, lawful means. The means employed are reasonably necessary for the accomplishment of the purpose and not unduly oppressive upon individuals. Reasonability test. The limit to police power is reasonability. So the court looks at the test of reasonability to decide whether it encroaches on the right of an individual, so long as legitimate means can be reasonably led to create that end, it is reasonable. Next power is the eminent domain. This is an inherent right of the state to condemn private property to public use upon payment of just compensation. The right of eminent domain is the ultimate right of the sovereign power to appropriate not only the public but the private property of all citizens within the territorial sovereignty to public purpose. There are two mandatory requirements that should underlie the government's exercise of power of eminent domain. First, it is for a particular public purpose and just compensation should be paid to the property owner. Eminent domain requisites: necessity, private property, public use, taking, just compensation, and due process. What is taking? There is taking when the following are present. The expropriator must enter the private property. The entrance into the private property must be more than a momentary period, and the entry into the property should be under warrant or color of legal authority. The property must be devoted for public use, and the utilization of the property ousts the owner and deprives him of all beneficial enjoyment of the property. What is just compensation? It is defined as the full and fair equivalent of the property taken from its owner by the expropriator. The measure is not the taker's gain, but the owner's loss. So the word just is used to intensify the meaning of the word compensation and to convey thereby the idea that the equivalent to be rendered for the property to be taken shall be real, substantial, full, and ample. The determination of just compensation generally is computed at the time of the filing of the complaint for expropriation, except that at the time of the actual taking, when taking precedes filing the complaint. At the time of the payment, if after an equitable lapse of time since the actual taking and the government's offer to pay. The last power is the power of taxation. So it is the power of the state to raise revenue to defray the necessary expenses of the government. It is the enforced proportional contribution from persons and property enforced, levied by the state for the support of the government and for all public needs. It is as broad as the purpose for which it is given. So the purpose: raise revenue, tool for regulation, protection, and power to keep alive. But we have to take note on the lifeblood theory. So taxes are the lifeblood of the government, for without taxes, the government can neither exist nor endure. A principal attribute of sovereignty, the exercise of taxing power derives its source from the very existence of the state whose social contract with its citizens obliges it to promote public interests and common good. The theory behind the exercises of the power to tax emanates from necessity And without taxes, government cannot fulfill its mandate of promoting the general welfare and well-being of the people. So that ends the basic concepts of political law.